Hi, my name is Akiva Goldman. I'm the founder and director of Goldman and Associates. Our firm has a primary focus on family law with a secondary focus on criminal law and negligence work. If you have any questions or interest in those areas, please, of course, subscribe to our channel. You know, we talk a lot about mediation and the mediation process as it relates to divorces. You know, it's a very inefficient way to run your household by having some guy in a black robe say, okay, this is what you're going to do with your kids. You shall do this and you shall do that. And to have it done like that, even the courts feel that they don't really want to tell you how to run your household. They don't really want to tell you what to do with your family, so the courts will many times order a case that's unresolved. The court will many times order it into mediation. The court will either let the parties hand select a mediator, or maybe the court will pick its own mediator in an effort to try and bridge the gap and resolve those issues so that the court, frankly, doesn't have to deal with it. And that's really the goal, to take that decision out of the court's hands so the court might not have to make that difficult choice. It's the theory being that if a mediator will help parties come to their own agreement, even if you feel you're giving in a little and the other side may be giving in more than they want to, it's better. Better than to compromise a little than to have a judge say, okay, you shall do this and you shall do that, and that's it, you got no say. So that's the concept of mediation. But, like many parts of our court system, sometimes it doesn't work. Sometimes the mediation is unsuccessful. Sometimes after multiple attempts, the mediator just can't bring the parties to where they got to be. What happens in that case? Well, the answer is, if the parties cannot mediate successfully, then that's why we have trials. The court will hear a report from the mediator that it was unsuccessful. The court will probably convene the parties for a final settlement conference if it feels it might be able to twist some arms. But beyond that, the court will set the matter down for trial. And in the trial, that'll be just like you see on TV. There will be opening statements, there will be witnesses, there will be exhibits, there will be cross-examination. People will be called in to take oaths under penalty of perjury. They'll give their opinions, there will be objections as to foundation and hearsay and all these other things. And then ultimately the court will rule. And I gotta tell you, while that may be similar to what you see on TV, here's something that you might not expect. The court will rule, but it doesn't mean the court's going to make a decision from the bench. It doesn't mean that the court's going to decide at that moment, as the judge, is sitting there hearing proofs. I've heard enough. Here's my ruling. Click. That's not how it works. Many times the court will, rather than issue that bench opinion, will issue a written opinion, and sometimes that written opinion will take months for you to get it. And then, once you get it, there may be an issue. The court will often say, this is the opinion, the parties are ordered to draft a judgment of divorce that, comports with the opinion, and then you get other, issues. Does the judgment comply with what the judge said? What did the judge mean? Is there clarification required? Motions back and forth before the court. All this in order to get it finally signed. And then after it's finally signed and it's a final order, then of course, you got to wonder, is somebody going to appeal? And if it appeals, that's a whole process. So my point is that there's a good reason to have these cases mediated. There's finality associated with coming to a resolution. It's like I said, even if you gave a little more than you wanted, or maybe you got a little less than you wanted. Maybe you wanted another day or another overnight with your child and you didn't get it. Or maybe you feel that the other person got more. Remember one thing. The process that I just described in a few seconds as we were going through this, that process, when you're going through it, seems like it takes forever. And in some ways, it kind of does. Because there's no finality in the court making a decision, and then you're being subject to appeals. So, generally speaking, the idea is, let's get as close as we can. The issues that we cannot resolve, we'll go to a mediator, and we'll really try to resolve them there. That makes a lot of sense. And that's a process that the court put in place because it acknowledges how cumbersome the alternative is if you can't resolve it on your own or through the help of a mediator. If you have any questions about that, of course, reach out. We'll be glad to help you out. If you've got a mediation coming up or some emergent need, please call now for immediate assistance.